Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. Happy Saturday. It is Pam Esquire, also known as your Law Intellect. Yeah, I have the t-shirt on today, actually. Law Intellect. Y'all see that right there? Got the cup today. Feeling real merched out. How is everyone doing this Saturday? You guys stretch your hand towards this internet over here in this house. I don't know what's up with it, but it's going in and out. So hopefully we'll make it through. I am here. I know it's 10 o'clock on the East Coast, but, you know, we got to make it do what it do. Hey, Courtney, thank you so much for coming and joining. Y'all make sure you know how it goes. Hit the like button. Thank you for all those people that have already hit the like. Make sure that you hit the subscribe. Let everyone know that we are on over here. And if you are new to the channel, welcome. There's a lot of new people that have said that they are new subbies in the comments under the last video with Tory. Them people was tripping over Tory Lanez. They was in there, free Tory. He will in about 7 years, okay? Just be patient. Just be patient. But anyways, hey, Lamario, Love Jones, what's up? Moon Eyes, Deborah, Miss V, Cynthia, what up, Andrew? You said I was praying you were going to cover this. I watched a few people kind of talk about it a little bit, but it definitely needs some clarification on what's going on. That's clear. Giger, hey, Courtney, Miss B's, Tory up. I know, right? I am up late. Well, I had to wait till the house got quiet so that I can actually do the live. I've been trying. I was going to do this live when this document dropped 3 days ago, but then all the stuff happened with Tory, so I was dealing with Tory. So, you ready? Hey, hey, hey. You know. Oh, that's nice. I have to get me one of them. I've seen a lot of people have merchandise, but I love your shirt. It's better than one. Thank you. I have to put the merch out first, though, before you can buy it. I haven't put anything out. I don't know. And my sister-in-law and everybody is like, put it out, put it out. And I haven't put it out yet. But anyway, Elite Leo, what up, though? Dev is actually at work, but maybe he'll pop into the chat to see what's going on. Otherwise, do I got any mods in here? I might have to add a mod or something on here. Wait a minute. Make sure you guys hit the like button on your way in. I don't think I have any mods on here. What the what? Guess it's late, huh? Miss B said the West Coast is still early. Oh, yeah. I did. It was great. We were downtown LA. Thank you for asking, Tutoria. It was cool because I haven't, you get everybody becomes adults. My brother went to school in Michigan, but he immediately was like, I'm out. Because Michigan, this area is kind of a place where you get stuck. And a lot of people get stuck here. And I noticed that it's a lot of talented people that probably if they went to California, Atlanta, wherever, they would have been better in their professions, but you get stuck here. He was one, as soon as he went to college, he was like, I'm out. So he's been living in California almost his entire life. And so he took me to this restaurant. Well, he and his friends were the ones, I guess, that covered it, which was cool. to some restaurant downtown in LA, and it was pretty dope. Thank you so much for asking. I had a really good time. It had been years since I had been able to spend time with him, so that was pretty cool. Yeah, Love Jones, you do. I don't know if I could. Let me see if I could. I gotta add a mod on here. Okay. So for those of you guys that don't know, hopefully that worked, Love Jones. I don't know. Dev usually does the mod. So like when people say they want to be mods, he usually is the one that does it. But again, he's been working a lot. For those of you that don't know, my husband about a year ago, he was very, very ill. Like, don't know if you're gonna make it ill, like in the hospital. And so he was always a hard worker. And so it was hard for me to get him, to sit down because he's still used to covering everything. Regardless of how much money I make, he still feels like his job is to cover stuff. So now that he's back, and a whole lot better by the grace of God than what he was, he just works. I have to tell him to slow down sometime because there was a time where he couldn't. So I try to not say anything about it, but But he is the one, I said all that to say, he's the one that typically covers all of the moderation stuff. But gotcha. Yes. Yeah, I know. Yeah. I know a couple of people on that. I know almost everybody. I know a couple of people on there on the Love and Marriage. Yes. Okay, so anyways, a lot of us know about the whole Cardi B, Tasha K situation. If you don't know, we're going to end up going over it in this document. So Cardi B, Tasha K and Cardi B, they were in trial at one point over defamation over some allegations that Tasha K put out. They went to trial. Cardi B won. There's a breakdown of, I think, cumulatively around $4 million of what Cardi B received in a judgment. Cardi B has went on this quest to collect her money. Recently, Tasha K filed for bankruptcy. Now, when she filed for bankruptcy, it was a Chapter 11. So it wasn't like Chapter 7 where you wipe everything out. It's a reorganization. People think that bankruptcy, and I'm not a bankruptcy attorney, but what Tasha K has just done, not Tasha K, what Cardi B has just filed that we're going to go over now tonight, I have been involved in something similar to that. Because what happens is people think like bankruptcy, you just kind of file, it's a bunch of paperwork. In theory, it kind of does go that way. But then you get some people that's not buying the whole bankruptcy situation. And when that happens, you have disputes within the bankruptcy. And a lot of people don't know that bankruptcies can get real messy. And this looks like it's going to be one of them. So when you have a bankruptcy, sometimes lawsuits are filed within the bankruptcy. Hey, Sam, good to see you. You can file lawsuits within the bankruptcy, and a lot of people don't know that. And and what it's called is an adversarial proceeding. So in my situation, I had a client that I represented, and it usually happens kind of in the entertainment section. I do some entertainment. You'll see some, if you follow me on Instagram, some of my clients or whatever, and some sports. But I don't do it. Usually it's people I know and have a familiarity to that I do it for. So don't recommend me to nobody because that's not really my thing like that. I don't like doing it like that. It's cool, but it's just, I like to litigate. I am a litigator or a trial attorney. So I like to go to trial. And a lot of that entertainment stuff doesn't do that. It's a lot of contracts, negotiations, things of that nature. So I had a client who filed for bankruptcy, and in that bankruptcy, there was a service contract. So sometimes you'll put contracts in there, and once it goes into bankruptcy and it gets discharged, then you're out of that contract. So that person that one of the people that my client had a contract with had a lot of money. So he wanted to fight the discharge. And in order to fight the discharge, you have an adversarial proceeding. Now, an adversarial proceeding, like I said, is like you filing a whole lawsuit within your bankruptcy. And people do it for different reasons. They might say that your bankruptcy is fraudulent. They may say they don't agree with you transfer property within a certain amount of time and you're not supposed to. Or, like in this case, you can say that your debt is non-dischargeable. Now, the question I know a bunch of you probably have is, if it's not a Chapter 7, it wouldn't be non-dischargeable anyway, right? Because really, what Tasha K said, what she relayed is, listen, I'm just trying to make payment arrangements. That's a whole lot of money, and I'm trying to make payment arrangements. So you would think because of that, then the non-dischargeable aspect wouldn't come into place. Well, that's not necessarily true. What happens is a plan is created to pay all this debt back. And sometimes that plan may include eliminating some of the debt. And it's like you have a whole new contract with somebody. So say I'm owed $100,000, but we come up with the plan. I'm a creditor and I approve of the plan. My stuff may get reduced to 70,000. So it's not always necessarily true that none of it is discharged just because you do a reorganization. So what Tasha K's attorney did is he or she, I don't know if he or she, filed a complaint. So they filed a lawsuit within the bankruptcy like 3 days ago. So, and we're going to go over that right now with no further ado. So this is the lawsuit that was filed in bankruptcy court. As you see, it's in Ray Latasha Transrena Kibi as the debtor and Belcaris Marlena's Alma, Cardi B. Okay. So now she made herself, as you see, the plaintiff versus her. So she filed a complaint to determine the non-dischargeability of the debt. So you guys know the parties in jurisdiction in the venue. You have to make sure that you're in the correct place. So we're not even going to go over that. So we're just going to go over the factual background. And I'm going to read some of it, but she does get into some of the allegations. And because YouTube do not like you mentioning and saying certain words, like my last video, I guess, when I was going off a little bit on Tory, they took some of that monetization off. So some of the stuff is going to be up there for you to read, but I may not say. So it has the factual background. Plaintiff is a Grammy award-winning musical artist, songwriter, and television personality, professionally known as Cardi B. Since the release of her full-length debut mixtape in 2015, Plaintiff's musical works have reached peak positions on charts in the United States and around the world. As a result of the popularity of her music, Plaintiff has millions of fans in the United States and around the world who follow her work and her social media profiles. In addition to her artistic endeavors, Plaintiff is well known for her volunteer work and philanthropic endeavors, which include helping families affected by gang violence and performing volunteer work and handing out costs to underprivileged persons. So those of you that don't know who Cardi B is, here is a background, a brief bio of who she is. Then we have the defendant. Defendant produces, hosts, and publishes videos on YouTube and other social media platforms entitled Unwind with Tasha K. Pre-petition defendant with malice and the intent to injure plaintiff. Utilize her social media platform to spread false, malicious, and defamatory statements about plaintiff. Defendant deliberately spread such false and defamatory statements even after being apprised of their falsity in order to benefit financially as a result of defendant attracting substantially more viewers to her social media platforms than most of her other videos by spreading lies about plaintiff. Specifically, defendant made the following false and defamatory statement. You guys know the list. Here's the list. I'm not going to repeat it. There's a lot of stuff that was said up in here. By engaging in the acts and conduct specified in the defamation action, defendant willfully and maliciously injured plaintiff. Defendant was given multiple opportunities to retract the false and defamatory statement and videos, but defendant steadfastly refused to do so. So now we're going to get into the defamation action and judgment for plaintiff. As a result of defendant's malicious campaign to damage and destroy plaintiff's reputation among her fans and consuming public, on March 21st, 2019, plaintiff commenced an action against defendant and Kiwi Studios, among others. And it has the case caption, in which plaintiff alleged claims for slander per se, slander, libel per se, and defamation. There's 224 of you guys. If you guys could hit that like, that would be great. Okay. On January 10th, 2022, the District Court for the Northern District of Georgia commenced a jury trial lasting multiple days, in which the jury ultimately found defendant liable to plaintiff for defamation, invasion of privacy, false light, and intentional infliction of emotional distress, and further found defendant to be jointly and severally liable for the damages with co-defendant Kiwi Studios, LLC. It is very, very difficult to prove intentional infliction of emotional distress. So the fact that she won on all counts is interesting. As noted by the Georgia District Court in its jury instructions, plaintiff had to prove by a preponderance of the evidence that 1, defendant made a false and defamatory statement regarding plaintiff, 2, the statement was published, and then plaintiff had to prove by clear and convincing evidence that defendant acted with actual malice. Plaintiff met her burden, proving that defendant's actions in spreading false and defamatory statements show willful misconduct, malice, wantonness, and an entire lack of care. Indeed, the jury found the defendant acted with, quote, specific intent to commit harm, end quote. Accordingly, the jury awarded plaintiff damages as follow. We, the jury, and you see a picture of the verdict form. We, the jury, therefore award the plaintiff damages in the following amount: $1 million in general damages, pain and suffering, and reputational damage, $250,000 in medical expenses, and $1.25 as the total. So that was on the first. And then it has a true and correct copy of the jury verdict on plaintiff's claim is attached as Exhibit A. So it's after these documents. I do have it on here. In addition to the claims verdict, as a result of the willful and malicious nature of defendant's actions, the jury also assessed defendant and her co-defendant, Kiwi Studios, with substantial awards for both punitive damages and litigation expenses. So that was the initial award. And then in addition, there were other claims that were on there. And they have those on here as well. As described by the Georgia District Court in its instructions to the jury, before a jury can award punitive damages, a plaintiff must prove by clear and convincing evidence that the defendant's actions showed willful misconduct, malice, fraud, wantonness, oppression, or that entire want of care that would raise the presumption of conscious indifference to the consequences. Plaintiff met her burden. As a result, the jury awarded punitive damages to plaintiff as follows. So here's the second portion. As to defendant Tasha K, we assess the amount of $1 million as punitive damages, which is separate from any punitive damage against defendant Kiwi Studios. As to defendant Kiwi Studios, we assess the amount of $500,000 as punitive damages, which is separate from any punitive damages against defendant Tasha K. So we got that $1 million plus, let's see what was up here, 1.2. So that's 2.25, and then the 500. So that's 3. And then the litigation expenses. As to plaintiff's claims for litigation expenses, we award the amount of $1,338,753.47. Yeah, that's over $4 million. Yeah. Whoa. A true and correct copy of the jury verdict assessing punitive damages collectively with the claims verdict, the jury verdict, defamation action, and got all that in print, is attached here to as Exhibit B. As a result of the jury verdict, on February 17, 2022, the Georgia District Court entered a judgment, the original defamation judgment, in favor of plaintiff and against defendant in Kiwi Studios. A true and correct copy of the original defamation judgment is attached here to as Exhibit C. The original defamation judgment noted the jury's award to plaintiff of $1 million for pain and suffering and or reputational injury and $250,000 for medical expenses. The parties stipulated to reduce the jury award of medical expenses from $250,000 to $25,000. So basically, the parties agreed to reduce the $250,000 for the medical expenses down to $25,000. So that was reduced. Okay. The jury also found that defendant and Kiwi Studios were jointly and severally liable for these damages. So that means together and separate. The Georgia District Court, in its original defamation judgment, also included reference to the jury's award to plaintiff of $1 million in punitive damages against defendant and $500,000 in punitive damages against Kiwi Studios and $1,338,753.47. That 47 cents is just taking me out. And litigation expenses against both defendants. On July 19, 2022, the court amended the original judgment. So they have an amended judgment. In the amended defamation judgment, the court reiterated the previous award of $1,025,000 for pain and suffering and reputational injury and for medical expenses against defendant and Kiwi Studios jointly and severally, $1 million in punitive damage against defendant and $500,000 against Kiwi Studios, and $1,338,753.47 for litigation expenses against both defendants. So the $1,025,000 for pain and suffering is against Tasha and Kiwi Studios jointly and severally. $1 million in punitive damages was against just Tasha, and $500,000 against Kiwi Studios. So for punishment purposes, that's what punitive damages is, to deter you from engaging in this type of behavior in the future. And then both defendants are responsible for this $1,338,753.47 in litigation expenses. A true and correct copy of the original defamation judgment is attached here too as Exhibit D. Y'all. And I loosely followed this case, so I kind of knew, like, people were saying $4 million, but honestly, this is the first time I'm really for real, like, reading it like that. I think we may have, when the appeal happened and was denied, we talked about that, but we didn't. This was not a case that we followed like that over here. But again, because I saw other people that were somewhat reporting on this, but not really, I think it was unclear what was really happening, that this is considered an adversarial proceeding. Oftentimes, this is like a whole nother lawsuit within the bankruptcy. And sometimes these lawsuits for adversarial proceedings, they go beyond your bankruptcy. Like, they'll go on just like regular litigation. I know here, our case, it got a whole nother case number, actually went over to federal court, which was like right across the street. So I don't know if this bankruptcy judge is going to handle it. It depends on their local rules, or if they just have a regular federal judge does it, because it's really like a lawsuit. I go on. In addition to the monetary awards, the Georgia District Court, in its amended defamation judgment, permanently enjoined defendant and Kiwi Studios from publishing or republishing on the internet or otherwise the defamatory statements listed in a consent order, and defendants were ordered to remove, to the extent not already removed, any videos or posts that contain the defamatory statements listed in the consent order, and the titles of such videos and posts, to the extent they contain the defamatory statements, from their website and social media accounts. So I think this makes it clear for a lot of us who were wondering, was there some type of a gag order or injunction to prevent Tasha K from talking about Cardi B? Well, clearly there's not, according to this, aside from what is specific in the consent judgment, which we don't have access to. It's probably not, undisclosed. And it seems like, to me, based on what Cardi B's attorney is saying in this document, is it is specific to those comments that were made, which were the crux of this lawsuit, and the videos that were pertaining to this lawsuit only is what can't be, discussed. Okay. And they must have listed whatever those statements were in this judgment that we ain't privy to. So. Hey, St. James, thank you for coming over. We were, little modelists for a minute, but it's okay. It's all right. Defendants failed appeal of the amended defamation judgment. Now, this is what we went over the appeal. On July 29, 2022, defendant and Kibi Studios appealed the amended defamation judgment in the case. And on March 21st, 2023, the 11th Circuit Court of Appeals affirmed the Georgia District Court's amended defamation judgment. So basically they appealed, and, obviously we knew that the Court of Appeals, that appeals was denied it. Procedural background. On May 25th, L. Kibi filed a voluntary petition for relief under Chapter 11 of the United States Bankruptcy Code, and it has the site right there, commencing the main bankruptcy case style in Ray Latasha Transrena Kibi, has the case number in the bankruptcy court for the Southern District of Florida. In the latest amended schedules, it has all of this on here. It also has the post-judgment, all of the different information, right? I want to move over because I don't know what information is on there. Plaintiff retained the undersigned law firm to represent her in connection with this action and is required to pay its reasonable attorney fees and costs. So count one. So this is why they're filing it. They're saying non-dischargeability of debtor pursuant to 11 U.S.C. Section 523A and 6. Plaintiff realleges and repeats the allegations contained in paragraph 1 through 37 above as if fully set forth herein. This is an action to determine the non-dischargeability of the amended defamation judgment pursuant to 11 U.S.C. Section 523A6. Section 523A of the Bankruptcy Code provides that, quote, a discharge under Section 727, 1141, and 1192 of this title does not discharge an individual debtor from any debt, sub 6, for willful and malicious injury by the debtor to another entity or to the property of another entity. As evidenced by the punitive damages award to plaintiff, the amended defamation judgment is clearly a debt for willful and malicious injury by defendant to plaintiff. Wherefore, so this is what Cardi B is asking the court to declare. Plaintiff respectfully requests entry of a final judgment against defendant, determining that the amended defamation judgment is non-dischargeable pursuant to 11 U.S.C. 253A6, 2, cost of suit incurred herein, and 3, granting such other further relief as this court deems just and proper. So, what Cardi B is saying is, you can go ahead and try to discharge some of that other stuff, or you might be able to restructure some of this other stuff, but I'm going to want every dime of mine. That's pretty much what she's saying. She wants every dime of her money. And I think people, because this was not a Chapter 7, a lot of attorneys, I believe, well, I'm not going to say a lot, but I know at least I saw a few attorneys that went on other platforms and they were discussing this that were bankruptcy attorneys, because I am not one. Put that disclaimer. I am not one of those. But they were saying that with Chapter 7, this is non-dischargeable because, Chapter 7 wipes everything out. So I think in our minds, a lot of people were thinking, well, when you do a restructure, that shouldn't count then, right? Because she can't discharge it anyway. Well, when you do a plan, When you do bankruptcy, you submit a plan. Now, oftentimes the creditors agree to this plan for you to do a repayment. Sometimes that plan is, again, if I can get 70K out of my 100K, I might take 70K out of the 100K. So Cardi B is like, yeah, I'm gonna want all my millions. And wants the court to declare that, it is non-dischargeable. Now, what the court did in response to this is like a regular lawsuit. So Tasha K has to be served just like a regular lawsuit. The court issues a summons first, because you have a certain amount of days, as you guys know, that you to serve somebody. And it says that the summons is issued. They have, I think her answer is due September 8th of 2023. They gave an adversarial case number. Like I said, they do typically give you a whole new case number for this. And they're going to have a scheduling conference that'll be coming up. And this moves like a regular lawsuit. Like you can do depositions, you can do interrogatories or other what we call informal discovery vehicles to try to get information. It goes just like a lawsuit, like she has to answer this. So now she's saying it's non-dischargeable because it's non-dischargeable because it was because of the judgment under the law, as you see in paragraph 4, section 523A of the bankruptcy code. A discharge under this section does not discharge an individual debtor from any debt for willful and malicious injury. So what she's saying is that her debt does not qualify under the bankruptcy law or the bankruptcy code to even be discharged. So whatever y'all try to do, don't be putting my stuff in there because mine don't qualify. Yeah. Tasha K said that before. I mean, that's really what you do for Chapter 11. I don't necessarily think, I didn't take it as she was like just running from it. She was trying to do a payment plan. But again, I don't know if she knows that, but from my understanding, again, I don't do bankruptcy law. From my understanding, when you do plans, your creditors also have to agree to those plans. It's like a joint situation to agree. And sometimes those plans may entail reducing that amount. You get what I'm saying? So even though it's not Chapter 7 where everything's discharged, in theory, you can have part of your debt discharged. So if I say I'm going to take $10,000 a month over the next 10 years, obviously that's not going to add up to my $4 million. So some of that'll be discharged. It's almost like me renegotiating, like you refinancing your house or you refinancing your car. You're renegotiating it and you're coming up with a plan that you're saying you can afford. I don't know why my internet is like this. It is just wobbly. So the reduction is, yeah. Cardi B openly stated that she won't be satisfied until Tasha and her family are broke, busted, and disgusted, left homeless and in the street. That goes beyond justice. Oh, wow. Ooh. It's getting rough out there. Y'all put me up on game because this isn't anything I have been following. Of course, I knew about the $4 million judgment. I'm going to know, a lot of times I know about it just as an attorney because I do personal injury, and part of personal injury when I did a lot of it was defamation. It's a niche for a lot of people. You have defamation law firms, like the lawsuit that Whitehead filed against Tasha K. They have a defamation law firm. So there are people that just specialize in this area, but it is a personal injury. It's injury to reputation. So oddly enough, and people think that I'm weird, but I do keep up with cases, just period, to see where the trend is. Or sometimes it may be what we call an issue of first impression. So it may not have happened in my state. So what I find a law or a case in a whole nother state, and I say, hey, judge, I think we should follow what happened in Tasha K's case. You know what I'm saying? So that's why I keep up with it. So I didn't keep up with it like for the salaciousness like a lot of people do, I guess. I kind of kept up with it like, oh, this is interesting. How did this happen? Because defamation cases are very difficult to win, you know, because of the freedom of speech. You know, there's a lot of safeguards for freedom of speech. So it's going to be very interesting because again, this can go one of the cases, like I said, that I have, it's still going. And the bankruptcy, I think they discharged his bankruptcy maybe 2 years ago. So these adversarial proceedings, depending on how much money you got, can go on for a while. So I don't understand how people are arguing over Cardi wanting her money because it was a trial and Tasha K lost, and that is what the jury of the peers awarded Cardi. Yeah. And you know what? Cardi, to me, from what this document says, it sounds like, and maybe some of you guys, paid attention to it more than I did, but it sounds like Cardi was trying to avoid litigation and said, hey, why don't you take this down? You know, hey, sis, this ain't what's up. This ain't true. Can you take this down? You know? And it sounded like that didn't happen. So she tried to mitigate the damages as much as she could before she filed a lawsuit. And because of that, the jury probably found like, oh, there needs to be some type of punitive damages or punishment. And that's one thing about federal courts. A lot of state courts don't give punitive damages, which are punishment. We don't do it in state court here, but federal court does. And so that's one of the things that you may face if somebody sues you in federal court. You know what? She quadrupled down on her attack after the judgment just ruled. Well, and very interesting. That's why I said when I seen like a month ago and there was that back and forth again on Twitter with them two. Yeah. Courtney said, for the one saying it's for revenge, it's not, because if the shoe was on the other foot, TK would be going harder on Cardi. Yes, guys, please make sure you hit the thumbs up. It's 326 of you guys hanging out with me at 10:30 on a Saturday. Now, I know you guys are getting ready for church. Like, this is the time that you get your flat irons and your pressing combs and hit those edges. I remember when I was a kid getting ready and ironing clothes for church. But you guys are hanging with me, and I appreciate it. Make sure you hit that like button. Subscribe if you haven't done so already. T.S. Madison is suing Tasha K. Now, oh my. Jeez, oh Pete. For what? Did she say she was gonna sue, or do we actually see a lawsuit? Y'all email me lawsuits when they come. Like a lot of people that say that I'm suing next. I got next. I think so, right? No, St. James, they don't. Just my house. Don't forget about TK saying the judge took a what? Child, listen, I didn't know that happened, so I couldn't forget it because I didn't even know that happened. The whole situation is messy and the shenanigans isn't serving me nor adding any value to my life. Okay. Hey, guys. Okay, guys, make sure you, like I said, hit the like, hit the subscribe. For those of you that's coming in, because it's like 350 of you guys up in the house. I see the Thai Squad has made their way over here. Shout out to you guys. Yeah, Cardi B has filed a lawsuit, which is called an adversarial proceeding, which within the bankruptcy, because she wants the court to declare that her debt, regardless of what plans they come up with, is not dischargeable. So do not throw me in your plans because I want all my money. So that's going to be some more back and forth going on between them. Yeah. Oh, it was some doxing going on. Oh, okay. You're talking about the passport situation. Got it. Okay, on TS Madison. Yep, I think I talked about that. I was over on Thais's channel and I talked about that over there with him. With Thais. Hey guys, hey Ty Libra, hey everybody coming in here. I see you guys. I see you guys. Do you guys have any questions for me? It's 376 of you. I feel like I should be talking about something else right now. Y'all gonna make me change the caption. No, I'm joking. Do you guys want to hear about? Okay, so many of you guys also know that Tasha K, that Bishop Lamar Whitehead has sued Tasha K as well, and has sued for defamation. That is over there in the federal court of New York, and in that case, because Tasha K is in bankruptcy, the case against Tasha K personally is stayed. So there's nothing that can happen as it pertains to that. Now, the new Kibi Studios is dissolved. Apparently, they dissolved it after the judgment. You guys seen all the numbers. If you didn't, y'all rewind to the beginning. So you seen all the numbers of what Kibi Studios took a hit from this lawsuit waged by Cardi B. So they're dissolved. So now there is a new entity called Yellen, which is the ones which is, I guess, produces the Tasha K Unwind with Tasha K. And so Whitehead has filed a lawsuit against Yellen and Tasha K. So of course the Tasha K is stayed because of the bankruptcy. When you go into bankruptcy, all of your judgments, all of your lawsuits, all that stuff is stayed. So that's stayed right now. So Yellen wrote a letter to the judge because they wanted to apprise the judge that they believe they have a reason to request a dismissal of this case. And what happened was the judge said they put a list, and we went over that in a previous video, so I don't want to redo that. But they were saying basically all the information Tasha K said about Whitehead was from judicial proceedings, or was true or substantially true. So that was, they kind of listed what their arguments would be if they did a motion to dismiss this case, because they're trying to dismiss it on the pleading, where the court ordered that Whitehead respond to that motion, to that request, to that letter request that they gave to the judge. So Whitehead did respond and basically said that, basically was saying that what Tasha K, well, what not Kibi Studios, what Yellen was saying was not applicable, and that he did have a claim against Yellen Studio, Yellen Entertainment, or whatever they're called. Let me see if I could pull up his document. I think I might have kept it. Since we're here, we might as well just get it over with, right? Because tomorrow I got to talk about something else. Yeah, so Whitehead was basically saying in his response letter, he was saying, no. We do have a defamation claim against Yellen, and that it should not be dismissed. So Yellen recently replied to it. So we're going to look at the actual reply that they had. Let's see. While we're here. So basically, and the reason why I'm just going to do the reply is because the reply, which is from, oops, sorry, this is the wrong one. Hold on. I got so many documents from him. Hold on one second. Tasha K. This is a shame. I got so many documents. Hold up. Let me look this up real quick. Give me 1 second, guys. You guys talk amongst yourself so I can look this up real quick. Because I wasn't planning this. I'd have been more organized. So don't be in my comments talking about, why don't you be more organized? Because I wasn't planning on doing this, okay? That's why. Let's see. And I'm going to start deleting some of y'all with these smart comments y'all be making. So, okay, I'm going to go. Let me do Whitehead's response, I guess. Motion in opposition. I'll do his response so it don't look like I'm not being fair. Because I did do Tasha's first one. So who do we root for in this situation? Ray, I just report. That's it. I'm just reporting. Let me see. All right, guys. Guys can see that. So this is what Whitehead said. So plaintiff, he's in opposition of defendant Yelling Entertainment lies Rule 12b6 motion to dismiss. Okay, so we're going to go down here to their argument. A complaint must contain a short and plain statement of the claim showing that the pleader is entitled to relief. However, a defendant may move to dismiss the plaintiff claim. So it's just saying what a Rule 12b6 is. So we're just going to go through that. Yelling Entertainment moves to dismiss Bishop Whitehead's defamation. Bishop Whitehead and pleader. Defamation claims on 4 grounds. 1, Whitehead's claims are barred because many of the challenge statements are fair and true reports of judicial proceedings. 2, Whitehead's defamation claims are barred because most, if not all, of the challenge statements are not actionable as a matter of law. 3, Whitehead's defamation claims fail because he has not alleged and cannot plausibly allege that the challenge statements were materially false. And 4, Whitehead's defamation claims fail because he has not alleged facts plausibly suggesting that Yelling Entertainment acted with actual malice as required by the First Amendment and the New York anti-SLAPP. So these were the reasons why Yelling was saying they were going to file a motion to dismiss. And the court said that Whitehead had to respond to their memo saying that they're about to file this motion to dismiss. And he said these grounds fail. Next, Yelling Entertainment moves to dismiss Bishop Whitehead's right of privacy claim on the grounds that Yelling Entertainment was not engaged in advertising, but rather reports of newsworthy events of matters of public interest, namely a federal indictment and other legal claims against a prominent preacher, which cannot be the basis of Section 51 claim. These grounds also fail. So his first response to what Yelling had to say is Bishop Whitehead's complaint states a claim for defamation. So he goes under what New York law says about the elements for defamation. We don't need to go through that. New York law recognizes several qualified privileges, none of which Yelling may prevail under. First, Yelling Entertainment seeks to assert that it cannot be held liable due to a purported fair report privilege. New York has codified the fair reporting privilege into law. The statute states a civil action cannot be maintained against any person, firm, or corporation for the publication of a fair and true report of any judicial proceeding, legislative proceeding, or other official proceeding, or for any heading of the report, which is a fair and true head note of the statement published. This section does not apply to a libel contained in any other matter added by any person concerned in the publication or in the report of anything said or done at the time or place of such proceeding. Noticeably, this is Whitehead now. This is his response. Noticeably, Yelling Entertainment Purported fair report privilege fails as it failed to cite to any judicial proceeding, legislative proceeding, or other official proceeding, and it failed to demonstrate that it gave a fair and true report of the same. Thus, it cannot enjoy the privilege. So they're basically saying that Yellen did not show what judicial proceedings they were referring to when they were saying that Tasha K, what she reported was a fair report. And in their reply, Tasha K is very specific, so I'm gonna put that. Well, it wasn't really Tasha K again; it's Yellen, because Tasha K is stayed because of the bankruptcy. So that's that. Then he goes on, a publication is deemed fair and true if it is substantially accurate, and it gives all the law, as you guys see, all the case law. A report cannot be said to be substantially accurate, however, if it would have a different effect on the mind of the recipient than the actual truth. In other words, Section 74 does not afford protection if the specific statement at issue considered in their context suggests more serious conduct than what actually suggested in the official proceedings. Again, this court has no judicial proceeding, legislative proceeding, or other official proceeding to rely on pertaining to Yellen Entertainment's purported fair report privilege. Notwithstanding the foregoing, plaintiff's position is that alleged defamatory statements in the complaint are not fair and true reports of any judicial proceeding, legislative proceeding, or other official proceeding, and thus are not subject to any purported fair reporting privilege asserted by Yellen Entertainment. Accordingly, Yellen Entertainment first grounds for its motion to dismiss fails, and its motion must be denied. Second, their second argument asserts that it cannot be held liable due to a purported opinion privilege. Most notably, Yellen Entertainment fails to state which of the subject defamatory statements are opinion. Yellen loosely refers to most or several of the subject defamatory statements in its motion. The court is not obligated to seek, search, or find what Yellen fails to demonstrate. So they're saying they didn't specifically say what was an opinion. That's their second argument. And their third argument is Yellen Entertainment asserts that it cannot be held liable due no allegations as to alleged defamatory statements being materially false. That reads horrible. Third, Yellen Entertainment asserts that it cannot be held liable due no allegations as to alleged. Maybe do no allegations, not supposed to be there, as to alleged defamatory statements being materially false. This ground is without merit. Plaintiff repeatedly alleged that the subject alleged defamatory statements in paragraph 56, 57, 58, 59, 60, and 61 of plaintiff's complaint were false. Paragraph 54 says, on or about late May 2023, Tasha K targeted Bishop Whitehead and maliciously began making false and injurious statements regarding Bishop Whitehead. Paragraph 55, on or about late May 2023, Yellen Entertainment via Tasha K targeted Bishop Whitehead and maliciously began making false and injurious statements regarding Bishop Whitehead. Paragraph 63, the foregoing highlighted quoted statements in paragraph 56, 57, 58, 59, 60, and 61 were false. Okay, he's just going through the complaint. Let's go to his fourth argument, why this case should not be dismissed. The fourth argument is Yellen Entertainment asserts that it cannot be held liable due failure to allege actual malice. Jesus. The issue was addressed above. Plaintiff adequately alleged that Yellen Entertainment published the alleged defamatory statements with malice, thus overcoming Yellen's purported opinion privilege and also the First Amendment in New York anti-SLAPP. Bishop Whitehead's allegations also meet the constitutional malice standard of knowledge that the statement was false or reckless disregard of whether it was false or not. Thus, this ground also fails. Accordingly, Yellen's fourth ground for its motion to dismiss fails. Thus, the motion must be denied. Now, he also added a claim of a right of privacy under New York civil rights law. So he's saying Yellen Entertainment also moves to dismiss Bishop Whitehead's right of privacy under New York civil rights law 51, based a purported defense that it was not engaged in advertising but rather reports of newsworthy events or a matter of public interest, namely a federal indictment and other legal claims against a prominent preacher, which cannot be the basis of Section 51 claim. Again, Yellen Entertainment is cryptic about its purported defense and cites no specific matters. In order to establish a violation under Section 51, a plaintiff must show the defendant made use within the state of New York of plaintiff's name, portrait, or picture for advertising purposes for the purpose of trade without plaintiff's written consent. Bishop Whitehead's complaint sufficiently alleges factual allegations to state a claim for violation of Section 51 of the New York Civil Rights Law. And it says, on or about May 2023 and thereafter, Tasha K used Bishop Whitehead's name and or picture for advertising purposes without first having obtained the written consent of Bishop Whitehead. On or about May 2023 and thereafter, Tasha K used Bishop Whitehead's name and or picture for advertising purposes for her website, for her paid subscriptions for non-public content without first having obtained the written consent of Bishop Whitehead. On or about May 2023 and thereafter, Tasha K used Bishop Whitehead's name and or picture for advertising purposes to solicit paid advertisers for her social media platform without first having obtained the written consent of Bishop Whitehead. On or about May 2023 thereafter, Yellen Entertainment used Bishop Whitehead's name and or picture for advertising purposes without first having obtained written consent of Bishop Whitehead. Y'all get the gist. So they're saying they supported all their allegations and that the case should not be dismissed. Let me go back over here before I get to their reply. Hey, Really B. Y'all make sure you hit the like button, please. Seriously. TK said very bad things about her and Chris. Okay, you guys, I'm interrupting your conversation. I did tell you guys to talk to each other. Tasha K said on her channel she wiped her with Cardi B's sister before they went. Oh, y'all still on Cardi B? Okay. Y'all got to rewind to the beginning to see this case on Cardi B. That she filed a whole new lawsuit. Okay, let's hurry up and see what the reply is. Let me go over here. So, of course, Yellen replied to this and was like, no, 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 no. And then I'll take questions and then we can get up out of here. So, Yellen did a reply to Whitehead's response. In this case, plaintiff Lamar Whitehead purports to allege 2 counts for defamation and 1 count for invasion of privacy against Tasha K and Yellen. Specifically, he challenges 6 statements made in 2 episodes of Tasha K Live, a news and entertainment series on the YouTube channel starring Tasha K and produced by Yellen, and objects to the use of his photograph to illustrate those news stories. The case against Tasha K has been stayed. Yellen has moved to dismiss because plaintiff's claims are inadequately pleaded and barred as a matter of law. Plaintiff's opposition does not offer any legally valid response to Yellen's arguments, and so the complaint should be dismissed with prejudice. Plaintiff's primary argument is that Yellen did not sufficiently detail his arguments for dismissal. Of course, Yellen's arguments were succinct because it filed a pre-motion letter in compliance with the court's rules. The fact that plaintiff is responding to Yellen's pre-motion letter rather than a more fulsome brief is entirely a problem of his own creation. Plaintiff also argues that Yellen has not provided, quote, evidence or requested judicial notice of its defenses. This is not necessary. Plaintiff's claims fails as a matter of law based on the complaint, the publication at issue and related judicial records, all of which the court can consider on a Rule 12b6 motion. Then it has the case law. Finally, plaintiff insists that he adequately pleaded his claims, but he cannot point to any facts plausibly supporting his claim, or any facts at all, only conclusory allegations and threadbare recitals of the elements. So, plaintiff has not alleged a viable claim for defamation. The Tasha K live episode at issue discusses plaintiff controversy surrounding him, including a pending federal indictment and an ongoing civil suit, and plaintiff's threats to sue Tasha K. Plaintiff objects to 6 specific statements. Statement 1. Plaintiff bought a $2 million mansion with only $10 in the bank. Now they're saying all these are the statements that Whitehead is alleging is defamation. The statement 2, Tasha K sensed that plaintiff, quote, tried to use me to intimidate a witness in a case. Statement 3, references to plaintiff's, quote, so-called credit card fraud and using people's identity to get credit cards. Statement 4, Tasha K's summary of a church's allegation that plaintiff convinced them to transfer its building to him and later evicted them, which could be considered fraud. Number 5, her speculation that the government is going to get a gag order on him. Statement 6, the assertion that plaintiff cannot sue her because his assets are frozen. None of the challenge statements are actionable, and even if they were, plaintiff has not plausibly alleged that they are provably false or that they were published by Yellen with constitutional actual malice, i.e. with knowledge that the statements were false or with reckless disregard as to their falsity. The claim should be dismissed. A, the first and fourth statements are absolutely protected by the New York's Fair Report privilege. Plaintiff does not dispute the New York's Fair Report privilege. So then they put the privilege. He also argues that Yellen failed to cite to any judicial proceeding, which is untrue. See motion at 1. Or that Yellen has not produced evidence that the statements came from those proceedings. The court, however, can evaluate the fair report privilege by comparing the publications at issues to the underlying proceedings. Then it has the case law. Moreover, requiring Yellen to produce evidence of its sources would defeat the purpose of the fair report privilege, which is a privilege from suit. Oh, wow. They said they don't even have to produce their sources. And then it has the law. Fair report privilege immunizes publisher from civil suit, sounding and libel. In any event, how a reporter gathers his information concerning a judicial proceeding is immaterial, provided his or her story is a fair and substantially accurate portrayal of the events in question. Finally, plaintiff insists that the challenge statements are not fair and true reports, but he does not point to any inaccuracy or mischaracterization that will remove the publication from privilege. And then they have the case law. The first challenge statement, this is how we get to what their arguments are. Tasha K's statement that how the feds found out that he only had $10 in the bank when he bought his house. Substantially accurate summary of the government's allegations in U.S. versus Whitehead, and they got the case number. And then they put the quote from the indictment. In an effort to obtain a mortgage in excess of $1.3 million to fund Whitehead's purchase of a home in Paramus, Whitehead altered bank statements to indicate that the account had an average balance in excess of $2 million, when in fact, during that time period, AMS LLC had an average pending balance of less than $10. So I guess Tasha K said, y'all want me to show you where I got the information from the documents? Here you go. For a challenge statement, Tasha K's description of Glory of God Global Ministries claims that plaintiff had tricked them into conveying the deed for their building to him, which could be considered fraud, is a fair and accurate summary of the church's deed fraud complaint. So then they attach the complaint. Sub B, the second, fourth, and fifth challenge statements are non-actionable statements of opinion. Statements of opinion and loose figurative or hyperbolic language are not actionable in defamation. And there's the case law. Plaintiff argues that this is a privilege that can be overcome by allegations of malice. Here, too, he is mistaken. Statements of opinion and hyperbole are not actionable regardless of intent because they cannot be proven true or false, as required by both the First Amendment and New York law. And then it has Rinaldi for its authority. Remember, I asked you guys, don't just say stuff. Make sure you have your authority, and they have their authority. At least 3 of the challenge statements considered in context as the law requires are not actionable, and plaintiff has not offered any explanation as to why he contends otherwise. Second challenge statement, Tasha K's explanation that she stopped interacting with plaintiff because he tried to use me to intimidate a witness in a criminal case is non-actionable opinion based on disclosed facts. In the episode, Tasha K explains that plaintiff encouraged her to publish stories critical of a man that he believed was an informant in the federal prosecution, facts that plaintiff has not alleged to be false, and opines that plaintiff did so in hopes that it would intimidate that source. And then it has the video where it was talked about. Though plaintiff may dispute that conclusion or deny that was his motivation, the statement is Tasha K's opinion. The matter is subject to public debate, and each reader may draw his own conclusion based on the disclosed undisputed facts. The fourth challenge statement here too. The episode outlines the allegations in the deed fraud suit, offers Tasha K's opinion that this could be considered fraud, and allows readers to draw their own conclusion. So they took a picture of the complaint, and it says, so apparently, let me tell you what, oh no, this is not from the complaint. This is what Tasha K said in her video. So apparently, let me tell you what he did. The church that he had wasn't the church that he bought. He knew the owners of the church. They needed to refinance their church, but couldn't, but didn't have the credit to do it. So what he did was told them to transfer the deed to his name. They were supposed to go get the church refinanced, get a lower rate. He'll give the church back to them at that rate. It was supposed to be an even exchange like that, but I guess they took too long to do the refinance, or it didn't work out. So what he did was evicted them out of his property because they signed the deed over to him. Now he evicted them right in the middle of his federal investigation, which could be considered fraud. The intentions were different, okay? So everything was done legal, but yet illegal, if you feel me. That was very confusing. I don't get the church situation, but hey, that's yeah. Say that for a different video. The fifth challenge statement is Tasha K's speculation that the government is going to get a gag order against plaintiff is also not an assertion of fact that can be proven true or false. Rather, it is a speculative statement about what might happen in the future and therefore also not actionable. Okay. Let me see what y'all talking about over here. I see we have a super chat. Thank you so much for always supporting a super sticker. Thank you, HFG. I appreciate you. Oh, TK had time today for Whitehead. He's trying his best to get some money from. Listen, Tasha K got some lawyers on this one. That's all I'm gonna say. She got some lawyers on this one. But I am going to, let me finish, and I'm gonna ask you guys if y'all think Tasha K might got a shot at this one as opposed to the one that she had with Cardi B. If y'all think Tasha K gonna prevail against Whitehead based on these facts and circumstances, this attorney and how this attorney is moving. Again, Tasha K's case is stayed right now. So this is just against Yellen. But I would presume that once the case is not stayed anymore, like once they come to a plan and Tasha K is released to deal with this litigation, they'll probably file the same motion on her behalf. I mean, why not? It seems like it pertains to both of them, but it's just Tasha's in bankruptcy, so her everything is stayed right now. Somebody mentioned Olga. Simon, where you been? You must have missed all them lives Tasha that did on Olga. Let's get back to this so I can get back to y'all comments because I love talking to y'all. Okay. Plaintiff has not plausibly alleged that any of the statements are false, and the third and sixth statements are substantially true. Several of the challenge statements are also not actionable because they are substantially true. based on judicial records which can be considered at this stage. And then it has the case law. The third challenge statement, plaintiff objects to the reference to his, quote, so-called credit card fraud and using people's identity to get credit cards. But he cannot prove these statements are false. He has been convicted and served time for 15 counts of identity fraud committed by opening credit cards in other people's names. And then they have attached as an exhibit, People v. Whitehead, the Suffolk County case. The sixth challenge statement, the statement that plaintiff's assets are frozen, even if not precisely accurate, and plaintiff has not alleged that it is false, would have no different effect on the reader than the other undisputed facts, including that plaintiff is under federal indictment and that the government is seeking to forfeit his assets in that case. Second video. Plaintiff claims based on the first, second, fourth, and fifth challenge statements should also be dismissed for failure to plead falsity. He has offered only conclusory allegations of falsity without articulating what about any of the statements is provably false, much less plausibly suggesting that is the case. D, plaintiff has not plausibly alleged actual malice. And we've been over that 5 million times on this channel, so we know what actual malice means. And it's not what it sounds like. Plaintiff does not dispute that he is a public figure or that the video issue addresses matters of public concern. Thus, under the First Amendment and New York's anti-SLAPP, and we've been over that ad nauseum, the anti-SLAPP statute, plaintiff must plead plausible grounds to infer actual malice by alleging enough facts to raise a reasonable expectation that discovery will reveal evidence of actual malice. As plaintiff cannot point to any non-conclusory allegations that would satisfy their standard, only threadbare recitals of the legal standard. Both of his defamation claims must be dismissed. 2, plaintiff cannot allege Section 51 claim based on newsworthy publications. New York courts have time and time again held that where a plaintiff's picture is used to illustrate an article on a matter of public interest, there can be no liability under Section 50 and 51. And that's under Messenger v. Gruner. Plaintiff does not dispute that the publications at issue reported on matters of public concern, and so he cannot show that his image was used for, quote, advertising purposes as required by Section 51. Plaintiff argues that the videos are advertising because Yellen could have profited from them. But New York courts have rejected this argument for decades, and that's in Stefano v. News Group publication. The fact, and then what they stand for the proposition is the fact that the defendant may have included this item in its column solely or primarily to increase the circulation of its magazine and therefore its profit does not mean that the defendant has used the plaintiff's picture for trade purposes within the meaning of the statute. As the video undisputedly involved matters in the public interest, plaintiff's Section 51 claim must be dismissed. For the foregoing reasons, Yellen respectfully requested the court grant its motion dismissing plaintiff's claims in their entirety and with prejudice and grant such other further relief as the court deems proper. So what it looks like, and I know we have been over motions to dismiss over here several times on different cases. The way this court's local rules are, they make you write a memo and you pretty much ask for a pre-conference is what I'm gathering. And you do a summary of what your arguments will be. So once you present your summary, what happened is they followed the local rules, they being Yellen, they followed the local rules. They did their summary like, hey, we're going to file a motion to dismiss under 12B. And these are the reasons why. And then the court said, hey, you know, Whitehead, y'all got to respond to this. So then they responded, and that's what we went through at first. And then this is the ultimate reply to their response. So I believe that the court may still make them do a whole full-blown motion, because even though these were 10 pages, when they do their motion to dismiss, it'll probably be about 22 pages. Like it's going to be double this. It's not as encumbersome as when you're just doing a little memo, even though this seemed long because I was just reading it and all of that. But I want to know from you guys, do y'all think this is going to be a Cardi B situation? Or do y'all think Tasha K about to win. Yelling entertainment right now because Tasha K is that. Y'all think Yelling about to win this case? Who do y'all think? Y'all think Whitehead got it, or y'all think, based on what I just read and the law that we have just articulated, who do you guys believe is going to come out on top? Do you think he's going to win this multi-million-dollar lawsuit he has filed against Tasha K? With the exception of the church part. Yeah, that was weird. Her response seems solid. Really B said Tasha got this one. Love Jones said Tasha got Tasha. You think Yelling got this one, y'all? What y'all think? If anybody wants to come on, since we're all up late right now, you guys can come on. I'm going to put this in the chat. I'm not going to keep it in for a long time because we have been on over an hour. You know, I'm kind of an hour girl. So Yelling for the win. Okay. So we had the first case that we talked about, the bankruptcy, and it looked like, you know, Tasha gonna be into some wrangling. The bankruptcy then got messy. But now we got the second part with the Whitehead case, and it looks like Tasha might come up on top. It definitely looks like she has some very good attorneys, though. When I first read the dismissal, I was like, ooh, okay, Tasha, you better get you some attorneys. TK got this one only because he lies as much. You know what, Tory? He's not doing this. You said she should sue Whitehead and forward the winnings to Cardi B. You know what? Okay, well, look like Yelling got this one. I should have did a formal poll. Tiffany said he always thinks somebody's trying to. It ain't me. Chad, Google owe me some money. If I'm making hundreds of thousands and millions and all of that, then they owe me some money because I've been shortchanged since I've been talking about them. This is funny because they became friends to allegedly take down other people and now they fighting each other. I think TK will win the Greasy case because it doesn't seem solid. She definitely have a shot at winning this case because what she did say about it's true. TK got smarter. I'm not. And she had her listed in her bankruptcy too. I know she's done a couple of lives as well, where she said people were telling her, you know, that her attorney wasn't the best attorney, and she gave her a chance. You know, gotta start somewhere, I guess. You know, like I started out doing criminal defense when I first came, you know, over 10 years ago. I was doing criminal defense, and it's different than civil. It really is. There's some similarities, of course, but it's very. That's why we refer cases out to other people. And I say immediately, like bankruptcy. I know it's a lot of paperwork. A lot of paralegals prepare a lot of the stuff for bankruptcy, but you have to be there to argue it. But I don't do it, so I have no problem saying what I don't do or what I've never done. There are a lot of areas that I have done, you know, like tried, because I worked at a general practice firm when I first went. So I've done family law. I've done criminal, like I said. I've done landlord tenant. I've done some civil rights stuff. I've done, like I said, police misconduct, excessive force. That's what I really do now. And I do wrongful convictions more so now. I've done accident cases, personal injury, defamation. What else have I done? Contracts, of course. I told you I do some entertainment. I've negotiated some reality show contracts. I've negotiated record deals. I've created contracts for like some of your faves, you know, your favorite artists for their shows that they do. But child, but to go in from one, anything that I did, I had a mentor, somebody that was so seasoned. I don't care if I've been practicing 15 years. If I'm going to go into a new area, you get somebody that's seasoned to go with you. You don't just jump in like that. So when it was saying that it was a criminal defense firm, I was like, ooh. And federal court is different. There's a lot you can lose off a procedure if you don't know their rules, if you don't know the court rules, if you don't know the local rules, if you don't know the judges have their own rules, you can lose just based off of that. So yeah, but she seemed like she did all right now, where she does have an attorney that knows what they're doing, it appears. So let me go back down here. Is there a section of law I would never consider? And taxes. Don't come to me with no numbers. All I know is my attorney fee and my third, okay? And I know my tithes. I know 10% of anything. So I've been paying tithes since I was getting allowance at 5 years old. But other than that, no, I wouldn't do taxes. I wouldn't do secure transactions. I don't think I would do municipal bonds or anything like that. Corporate would probably bore me, but I think that's more comparable to a lot of entertainment stuff because that's contracts. They have specialty areas of law. So you have some people that deal with like animals, like horses. You have an area, a niche of doing, recreational. That's an area that's really booming now. What else wouldn't I do? I don't know. There's not too many areas I wouldn't try, or at least second chair if you're going to go to trial on. But it's just hard to keep up. I try to keep up with all of the new case law that comes down in that area. And that can be very overwhelming if you're practicing in too many. So that's why I just kind of limit it. Unless you're close to me like that, I wouldn't even say family because I don't like representing family at all. I don't even want to represent you on a ticket. But then it's people that just was like, I think I want you to do it, So it's a lot of people that just trust because they know my work ethic and I'm gonna figure it out and I'm gonna get somebody that's way better than me, probably that's gonna sit next to me. So they feel confident in it. No, I don't believe that that's for me. BB's kids, gammies. Maybe like when I'm on my verge of retirement. I think that I am more effective on the ground than I am. And I don't believe you should be a judge unless you practice. I think it's a horrible practice for people to go sit on the bench and they've never practiced before, to be over trials or over, cases, and you've never actually been in the mud. So maybe later on in life, I've had opportunities that I've turned down where people wanted to rally behind me. I mean, you never know because it's an elected for state. It's elected. I've had people that was like, I'll, do your campaign. You don't have to pay me, all of that. But I don't think that's where I'm at right now. There's nothing. I never had the desire for it. Like in law school, there were people in there that said that's what they wanted to do. That never was my desire. I've been asked about it so much, what made me kind of think about it, but that's not what I want to do. There's one case I want you to break down, but I know you won't touch it because it could get messy. What case is that, Ray? Tell me what it is, Ray. Tell me what it is. You said if he wins, he'll be off the chain several lives a day. You think so? Pam, will you be going over Kenneth Petty and Jennifer Hove lawsuit? Didn't I go over Kenneth Petty before, y'all? I think I did do something on Kenneth Petty. I didn't even see you in the green room. Hey, Toria.
Hey, sweetheart.
How are you?
Good. How are you? I'm so glad you got to go spend some time with your brother.
Thank you. Yeah, it was much needed. It was much needed. But
Yep,
yeah,
that
in
was
the
really
chat they were
nice.
asking me before you came up. I just didn't want to have you waiting. Yeah, I did go over Patty, but if it's something else going on, you guys got to email it to me because I don't follow everybody and I'm not on social media probably as much as your average person. Aside from YouTube, but yeah,
That
I don't
case,
mind going over it if you guys are gonna be over here to support it. Now, don't be having me read all these documents and y'all don't be over here watching me.
oh, well, I'll be there to watch that
What you
because
have to say,
I
Tory?
follow that Hot Shot radio. He goes over. He's a friend of Jennifer's, and he goes over all her court papers. He gets the papers like you do and read it, but he's not a lawyer or nothing. But he just supports her, and it's a it's a terrible thing what she went through. It really is.
Okay. So Andrea says she'll release pics and docs from her 94 case file that backs up everything she said. Didn't he plea or something? Like pled to the situation
He
without saying
he's
the
on
situation?
probation for that not registering to be on the list, the sex registry list when he moved to California.
Yeah,
He's
that's what
on
I went over. I didn't like go over the actual underlining allegation that happened that
well, his
he actually
wife
said.
wrote a letter. She wrote a letter to the court saying that he was the only one that could watch their baby, that he watches the baby while she goes and does her job and stuff. She paid all his legal fees, court costs, the money to be on probation. He has to do random drug tests anytime they feel like it. They can come in there and check all his social media devices, telephones, computers, his vehicle, everything. It's a whole lot of stuff with that case.
But
It's gonna
can't
take
he
you some time to dig it all up.
but can't he be at least usually they let you around your own kids. So they're not letting are they saying he can't be around his own child?
No, he can be around his own child, but
Oh,
he can't be with nobody else. He can't like go to the child's school or anything like that when the child gets of school age. He can't. Mm-mm.
yeah, you can only be within so many feet of any school or anything where there's children at. Hey Paula, how are you?
Without my question was, um, um, have you ever done help anybody do expunges, like to get their records expunged?
Yep, I've done that too. Hmm.
Oh, okay. Is it a long process?
Nope, not here. It's just a document. Most people do it. A lot of people do it on their own. Like we have some great expungement laws. We just overhauled our laws with a lot of lobbying, and they make it real easy. Like it's step one, step two, step three, and they make it where now it used to be you can only have one felony and one misdemeanor. Now they added where you can have more felonies and more misdemeanors. So no, it's not hard. It's just paperwork and then going before step by step, getting your fingerprints, getting your final disposition because you can't even try to get an expungement until after a certain amount of years. So you have to make sure that those years have elapsed and then you have a hearing. But yeah,
Oh,
it's not difficult at all. If you qualify
okay.
now, there's some of course some offenses where you don't qualify. And that's statewide. Federal doesn't have expungements.
Okay.
A lot of people don't know. Yeah. Hey Paula,
Just,
can you hear me?
I think she's muted.
Paula? No, she keeps muting her thing, muting her mic.
Okay,
No.
can you hear me now?
Yeah, I can hear you.
Yes.
How are you?
I'm good. I said she gonna not answer my question. No, I just had a question. I just a newly subscribed for the past, I guess,
Welcome.
couple of shows that you did, and I really like your commentary.
Thank
Um,
you. Welcome, welcome. You
thank
guys give her
you.
the right hand of fellowship over here in this comment. Paula is new over here. But go ahead.
But I've always believed Megan. But my question is, I saw on Twitter where a supposedly wannabe lawyer kind of read the documents and had stated in court that it is grounds for a new trial. Someone answered it in the chat, I think, but I want to get your point of view on it. Stated that playing that Kelsey's recording, that should have been done with the jurors outside of the courtroom or inside, the chambers, instead of doing it, with everybody.
So let me tell you what happened with that situation. So what happened is, presumably before this trial, it was already decided. So there was probably a motion in limine saying, don't introduce this tape, this recording. The defense, it was granted. So that was not anything that was going to be in the evidence at first at all. It was deemed where it was inadmissible. It wasn't going to be in the evidence, only for impeachment purposes, meaning if she says one thing, then you can use a small snippet to show that she contradicted it, like for those purposes only, but to play the whole thing, no. But what happened is there's a case in California where if there is, and I'm summarizing, I'm paraphrasing, but if there is any allegations against the prosecution of being biased or doing coercion or intimidation, unethical type practices, and getting some type of statement, then they can defend that. So what happened in trial was Tory's attorney, Magdesian, got up and he was on the roll for a minute. I was like, okay, I'm feeling him, because I wasn't feeling him at first. So he was on the roll at first, and Magdesian said, you're saying that you were scared and you were intimidated, and this is why you said what you said when you did your interview. She said, yeah. And he said, were you intimidated by the defense? It's like, no. And so then he pointed to the prosecution, and he kept harping on the reason why she was scared was, I don't know if it was scared for that interview or scared to testify. I don't recall. But I know that it came out that she was saying she was scared, intimidated, or something that was by the prosecution. And Magdesian kept harping on that. And it did what's called open the door. So you can have some things that are inadmissible, but if you open up the door, then it gets let in. Gotcha. So that's how it was let in. Now, of course, Magdesian objected when the prosecution went. There was a sidebar, and the prosecution, of course, said that they wanted to enter in the whole statement to prove that this was not coerced in any way. She was there with her attorney. She had like two attorneys. One was there, one was on the phone. She had her boyfriend at the time, her husband. So they were showing that this was the environment and she was comfortable and there was no type of intimidation. So that's what they were trying to prove, right? So in theory, even though everybody was going to hear the entire interview, it was being presented like, I'm proving that there was no type of coercion or intimidation or anything like that at this interview, because you guys opened the door, making it seem like we did something wrong and we want to defend ourselves. Like we want to prove it, prove that didn't happen that way. So of course, Magdesian probably objected to it. So there's probably a record where they can say, we really didn't open the door, and it's an appellate issue. So as long as they objected to it, the only thing when you go to the Court of Appeals, all they do is look at your transcript. You don't have testimony. You don't have any of that. Now, you may have oral argument, but literally that's why it's important to preserve the record. So you object all the time for those that watched the Melly trial, everybody was like, they doing all these sidebars and objections. No, you have to preserve the record, because if it was never an issue that you raised in the lower court in the trial, you can't bring it to the appellate court. So I'm pretty sure that his attorney raised it. So it's probably something that can be reviewed in the appellate court. But I don't know about saying that it deserves a new trial, because I know why they did it. They did it because at first I believe it was not going to be played at all. It was deemed where, okay, it's not admissible. She's coming to testify. That's just what it is. But because of this law, this case law, they opened up the door for it. And so then the prosecution got the right to prove that statement never came for, and it was no intimidation. I hope that answers your question.
It does. And I just have one more question. Sure. How did you feel about Tory's last tweet. Now, he did all of this in court, saying that he still loved Megan, and this and that. And I guess different people were posting, changing his words. He said, that basically stating he did say that he did do it. How do you feel about the tweet that he put out saying that he is still stating that he's innocent?
You gotta look at my last video, Paul.
I thought that I
went in on Tory.
well, I did see your last video, but I don't remember that because that tweet was he just tweeted that. I'm gonna have like you said, I'm gonna have to
like
go back.
When today? Are you talking about the one where he professed his innocence, right? I posted it on my community wall, unless it's a different tweet. Is there a different post where he was saying he only apologized for bringing out secrets and arguing, but he never apologized for what he was convicted of and that he was maintaining his innocence? Is that the same?
It was just like 1 or 2 days ago he posted again on Twitter about people are changing his words or
I think that's the same. I'm pretty sure that's the same one I did my live on. But
on your live, okay.
So let me see. I have never. I'm gonna read it. So I have never let a hard time intimidate me. I will never let no jail time eliminate me, regardless of how they try to spin my words. I have always maintained my innocence, and I always will. Is that the one?
Yes, ma'am.
Okay, yeah, that's what I did a whole lot. I was supposed to do this. I was supposed to do this live on Cardi B on that day, but then this came out, and I was like, "Oh, I got you, Tory, today."
Okay, I'll go back. But I was there to listen to that, but I have to go back on it. Thank you so much for my question. Answering my question.
Thank you for coming up and welcome. Thank you so much for subscribing.
Thank you.
I appreciate you.
What I wanted to know is if he's supposed to be locked up 23 hours a day in his cell, how can he have access to social media?
I don't think he directly has access to social media. I think that he directs, perhaps, and this is assumption, of course, I don't know for sure. He directs his people on what to post on his social media. So like he also did recordings once he was convicted, blaming the DA for various things. So I think that he just, and that was recorded and somebody obviously posted it. He doesn't have direct access. I mean, a cell phone would definitely be a violation. So,
well, I'm sure some guards probably got some money to give him a cell phone, because that happens all the time.
Yeah, but I know. I've seen it more so in prison than in the county. I don't think I've ever seen it in the county. He's still just in like what we call the county here, but like in the jail that you go to before you go to prison.
So I seen him do it in Baltimore all the time, and they busted a whole bunch of correctional officers for bringing in, just stupid things like to the women, Bath and Beyond body products and Bath and Body Works or whatever it's called, and cell phones, food, all kind of stupid things. They overhauled the correctional officers not too long ago down in Baltimore for all that mess.
Okay. But Paula, it's like literally the first 15 minutes of that video. It wouldn't even take you that long to see what my commentary was as it pertains to that tweet, what I feel about Tory.
Him maintaining his innocence, to me, he forgets about that jailhouse phone call to Kelsey, because he clearly admitted it on that call. That was like a jailhouse confession to me. And then after that day, my mind was made up. He was guilty.
Well, to his followers, they interpret it the same way Tory is saying that he meant it. But clearly the jury thought like you, because they found him guilty on all accounts. So,
do you think next week he's going to win that bond hearing, getting out on bond till his appeal is heard?
If I had a guess, I would say no, because he didn't get off on bond after he was you know, that was a bond request that was asked for him to be out until his sentencing, and it was denied. That's why he's been in for 8 months, 9 months, I think.
Plus, he violated it when he was on bond. How many times did they up the bond because of
Yeah,
him
he
doing
had a
different
couple of
things?
violations, and they was upping it by like 100,000 too. It was like it wasn't no chump change.
No, it
But
wasn't.
for
I'd
all
like
of
to
the
know
Greek
where
Tory
Bishop
people,
Whitehead is, where
for all
Bishop
the Greek
Whitehead
Tory
is getting
people,
that money.
they have the shirts. If you guys want to participate and support them, since you guys keep putting in my comments, free Tory. They have, you know, they have shirts and sweatshirts over there on his website for you guys to go around and support him and wear his shirt.
I don't think so. If I buy a T-shirt off of any content person, it's gonna be you. I love that
Oh,
shirt you
thank
have
you.
on,
Thank you.
and
Well,
I hope you put them out.
All right, I got you. I got you, Tori. Thank you so much for coming on. I'm gonna drop you down, and I want you to have a good night. Or go back in the chat.
You too. God bless you and your family, baby.
Thank you. You too. Thank you. Andrew said, "What? Let's see. What was he doing with Kelsey that night? Line dancing. He didn't whoop her either, I guess." Listen, Kelsey, for those of you guys that don't know, she submitted to the police pictures of her scars and all of that. But I think what they're alleging is that it was Kelsey and Meg that were fighting and not Kelsey and Tory. Just a mess. Whole case is just a mess. Thank you, Ray. I second that. Hilarious. Because his fans keep hyping him up and giving him the audience, keep the conspiracy theory, just do the time, man. That's what he said, Tory. We didn't say that. That's what that man is arguing. Let me see if I have any more questions. So we covered a lot. I got something else on Whiteheads, so I'm gonna try to go tomorrow. Y'all, I can't keep up. It's just the stuff is just coming so fast. So I'll try to come back on tomorrow. It may have to be late because I have to wait till everybody goes to bed so I can have a few I already hit that one. I have to wait till I have peace and quiet around here before I can anybody have any more questions about anything else? That was Tory's little woman size whooping Kelsey, that man. So that was the craziest when Sean, because the crazy part is Sean Kelly, who witnessed this whole situation with Tory and Meg and Kelsey and the bodyguard, he was called by the defense. Can you believe that? Like, he was called by Tory. And then he gets up there and puts the gun in Tory's hand. It was just everybody was like, what? Presumably, the defense had no clue that he was going to say this. It was clear by the reactions. They didn't know he was going to say this. But how do you not ask him, did you see my client do anything before you call this man? So they thought they were just going to get him on the stand to say that the two were fighting. Because he did say everybody was fighting. He kept saying they were all fighting. Everyone was fighting. This one and this one, this one. And I saw the flash came by the woman. And that was part of it too, where the Kelsey defense was coming in, because he was going to say he saw a muzzle flash over by where the two girls was fighting. But then he says he saw the flashes by the little guy. And that's when everybody was like, oh, he done put the gun in the man's hand. So Sean Kelly didn't turn out to be. And so what Tory's father was alleging is that Sean Kelly had talked to the defense this whole time, like their investigator. But of course, the prosecution has the right to talk to Sean Kelly too, to see what his testimony is going to be. So before Sean Kelly testified, I think they take him up to the prosecutor's office or some neutral location in the court building, and they interviewed him. So what Tory's father was alleging is that almost like he was a defense witness, but then after he talked to the prosecution, he didn't even want to look, at them. So he felt it was some type of, salt in the game that happened. I'm still trying to figure out why the 1 million winos haven't sent her $4 each to help pay off her debt to Cardi since they got so up to fight the judgment. You guys to be careful about these people in the chat. I love y'all. But some of y'all want some mess. So I'm gonna have to agree with you, Mimi. I would expect if y'all got me out here windmilling about anybody, I'm gonna be like, listen, I could pay for it. But I really don't want to go into my nest egg for this. So can y'all send me $1 a piece or something? I agree with you. It seems like since if you guys are windmilling and you like it, why not help her out? Since this your fave. Not gonna happen. It just goes to show you better make your decisions based on you'll be standing by yourself if people sue you. Tory said, I believe Rock Nation paid them off. Paid who off? Who is they? Let me know who they is, honey. Because we could talk about Rock. My issue with the Rock Nation argument was that if I'm the defense attorney and I'm going to blame Rock Nation for anything, trust me, I'm subpoenaing somebody from Rock Nation. They're going to at least get on the stand where I can give an inference. And I can say, Tory went to the Rock Nation brunch. Is that right? And that's when you first met Tory. And you invited him because you wanted him to be a part of your record label. True? And you offered him a contract. He felt like the contract wasn't fair. And they'll probably explain and be like, okay, thank you for all of that information, but I didn't ask that. I just asked you, did you think it was fair? Yes or no would suffice. And they'll say yes. And so he said he wanted to remain independent. And you still approached him, didn't you? Because you really wanted him to be a part of Rock Nation, didn't you? And you were willing to do. And has there ever been anybody else that has situations with Rock Nation? I would have went on ahead and they would have been on the stand. Like, what happened when you tried to not, be on with Rock Nation? What happened with you? At least have some type of evidence for what you're saying. What we say as attorneys is not evidence. So me saying in opening statements, Rock Nation, all of this happened because Rock Nation wanted him to sign and he wouldn't sign with them. That's not evidence. The jury can't consider that. So it was like, just like you not saying anything at all, unless you had some evidence to back it up. That was my problem with that Rock Nation argument. So people that was saying that, is anything plausible? Yeah, but you got to prove it. It's not what you say, it's what you can prove. The witness, this was personal between Jay-Z and Tory. He wanted Tory to sign and he wouldn't. Okay, so I explained that. That may be. That may be, and that's what his father was yelling, but that was not proven, Tory, like in court at all. You cannot just make those type of allegations, and he has to learn. Public opinion does not help you in court. You cannot be so focused on the public that you're not even doing what you need to do to protect yourself from a legal standpoint. This was a legal case. You are a celebrity. This was going to be high profile. I don't like the way this whole case just moved, because it didn't have to go this way. And I say that over and over again. I just don't believe it had to go as far as it went. I think a lot of this stuff was kind of brought somewhat on himself, the way he was moving and the way he felt he had to defend himself against people who aren't doing that time. And that's what I was saying in my other video. These people can rah-rah cheer you on, have whatever t-shirts, but you the one out in the yard. You're the one trying to make sure don't nobody put no honey buns on your bed. You're the one got to deal with that. Don't nobody else got to deal with that but you. So you got to watch letting people hype you up. Because what happens is people forget about you so fast. They forget about you. So you can be the best thing since sliced bread. It'll be a whole new Tory, next generation in the next, month or two, and they won't even remember who Tory is. And we're gonna see like who keeps writing him, who comes to see him, who hypes him up, who, you know, it'll probably be the same people that were always there for him. Probably his dad, his stepmom, his brothers, sisters, the baby mama that been there since middle school. It's gonna be the originals that are probably going to be there for him at the end of the day. Not none of these people that's like going around putting umbrellas in my chat and free Tory and being obnoxious. Those aren't going to be the ones that, you know, again, they don't got to do that time. And that's what pissed me off about them, because I just don't feel like it could have went that way. It could have been, you don't necessarily always get deported, permanently banned from the United States. It could have been crafted in such a way where, say, for instance, you get deported and it's only for a year, but you can still come back on a work visa. There's so many things that can be crafted when you have an immigration attorney that should be working with you from the beginning. I just didn't like the way all of this stuff, regardless, you know, and that's just the defense attorney in me. I'm not saying that no consequences happen because of what happened, you know, what Meg is, she testified that that's what happened to her. So I'm not trying to minimize that in any way, but it's like, I just didn't like the way this whole case was like this. How you get a guilty verdict with no weapon? That happens all the time. That happens. They don't. I'm gonna say more than half of the time they don't have a weapon, and nobody else DNA, nor was there any gun residue on it, because somebody said that he shot him. There was a long stretch between the incident and when the police found them. Anything could happen with that gun. Honestly, it could have been wiped off. It could have been, anything could have happened. There's a lot of, we can go through the ifs, if the fifths, we'll all be drunk. Like, I'm not gonna, it wasn't proven. That case, to me, the defense, and I said it in the beginning, this is where the defense made their mistake. In opening statements, they said, from my understanding, because I didn't come to the afternoon when Meg was going to testify, so I missed opening statements. So from my understanding, from what I was told, in the opening statement, the defense attorney said, the evidence is going to show that Kelsey is the shooter. As the defendant, you do not have the burden of proof. You never shift the burden to yourself. And that's because what you do is you take the responsibility off of the prosecution. Well, now as a juror, if I'm a juror and I'm a juror and I'm sitting back watching, and you tell me as the defense attorney that the evidence is going to show that Kelsey did it, you better show me Kelsey did it. Because now I'm looking to see if Kelsey did it. And if I don't see that, then you did it. Because you lied to me and told me that Kelsey did it. So that's what I'm saying about shifting the burden and shifting the mind, thought, the processes of the jury. So, I mean, that whole case was just, and yeah. And people talking about Meg lied. Meg, do you know how many, the reason why the state picks up cases just like this one is because oftentimes when it comes to domestic violence type situations, which means dating relationships, friendships, family, familial relationships, they change their mind. They'll say, oh, I was drunk. Oh, that didn't happen that way. They get 5 different stories. That's not unheard of. And you know what happens? They go through every last story, and then they let the jury decide. The jury heard all of Meg's stories. And even though they heard all of Meg's stories, they believed her last story on the stand. So it's a credibility issue. That's up to the jury to decide who they believe. And they believed her. And they didn't believe that Kelsey did it, especially when that was not proven while we were there. It just wasn't. I did not, Tory, I didn't say they didn't have a gun. I know that they had a gun. I'm saying that there are a lot. No, that's not true. It didn't. I was in the trial. There was a gun that was tested for DNA on the magazine. Tory magazine, meaning where the bullets were. Tory was excluded. On the actual gun, Tory could not either be excluded or included. So therefore, it could have went either way. That's what happened. So I don't know about no gun disappearing, and I don't think it matters. It was about the DNA on the gun. That evidence was actually entered into trial. That's what the argument was, because allegedly Tory got somebody to say he was even excluded from the gun, which is not what the original expert said on both sides. So just because you can't, it wasn't a sufficient sample to tell whether he was excluded or included. Now, when it came to the magazine, he was excluded from that. That's, where the bullets go. Let me go on here. Ray said, I knew he was guilty when I found out his supporters were called umbrellas. Your last name is Lanez. Why not street signs, traffic lights? I was told they're called umbrellas because that's the name of his label. Because I asked that in the last Cynthia said, thank you. At this point, people are going to believe what they want, no matter what was proven or not. And some wonder why there's still so many Trumps, so people are delusional. Yeah, people believe what they want to believe. I was in the trial, and it's not what you think, it's what you can prove. And would it have been different if he had Sean Hawley as his attorney? Perhaps. Sean Hawley also stated that she wouldn't have did the Kelsey defense at all. So y'all go on Sean Hawley and get on her head, because she's the lawyer and she had more evidence than any of us had. Hey, Andrew.
Hello.
How are you, sis?
Absolutely well. I you know what? I was not going to come up here, but I had to. I
figured it was coming. I
had to. I had to. But no, this is what I don't like. I don't like everybody that know me and ever heard my voice know I can't stand misinformation. I think it is a detriment to our community, and conspiracy theories and disinformation are going to really lead to some devastating consequences for our community, in my opinion, because when things are complex and we don't understand them well enough, we will more easily go to conspiracy theory than we will the truth, because we don't understand the truth. And then when you leave a vacuum of information out there, the conspiracy theorists will fill it, which is what happened in this trial. Meg stayed quiet for so long, then after she stayed quiet, her story was recrafted. If you were to look at everything from beginning to end, the only thing people say, oh, she lied one lie. She said one lie, that she didn't sleep with a leprechaun.
You know what?
And who wants to say that?
Wait a minute, Andrew, one second. I think that and I know you're talking about the Gayle King interview, but and that came up in trial. I think what people have to, she did say it was glass, and it ended up being, obviously it was testimony from a doctor that it was bullet fragments.
Exactly.
So it actually was. So
and she never told the public that it was glass, though. She never told the public it was glass. She told the police that it was glass.
Right.
And within 72 hours, I think. No, within 42 hours, because when she got there, if everyone remembers, or if everyone would like to look at what actually happened, when it happened, the girl showed up at the hospital. She said, I stepped on glass. The intake person put down, stepped on glass. When she was taken to x-ray and all of that, they came back and it's like, no, chick, you need to tell us what really happened. We just found bullets in both your feet. And so she's got quiet or whatever. So she went directly to surgery after that. She went directly to surgery and stayed in surgery for a few hours, according to her documentation, where they had to remove all of the stuff from both of her feet. Then she went to recovery. So think about that. You show up wee hours of the morning. You know how it is in an ER. You lie, you say this, you're trying to save everybody or whatever.
Because she said what domestic violence people do.
It's what happens.
They automatically call the police, because they usually say they got on a piece of a banana peel.
Yes,
and all
exactly.
Of that, the same thing. But my point was, like, what I was trying to tell her is, let's just say Meg lied 50 times. all of them times were brought up on cross-examination, and they believed her on the stand, and it's about credibility. So you may not believe her, and they don't have to believe her.
Right.
But a jury of her peers believed her, and he's convicted, and that's kind of what it is. And I don't know why people are in denial.
Well, that was okay. That and the evidence backed up what her story. There was not one point in that story where the evidence that was shown did not look like what she said happened. And what I was saying, okay, what people need to understand is they need to know the difference between the story and the narrative that Tory and his PR spun and what actually happened with her. Because, oh, she was up twerking and dancing and at a party 2 days later, when in actuality, it was 5 or 6 weeks later. So it wasn't true. It was 5 or 6 weeks later.
Who she was. I
mean, but my thing is that's. But my thing, you and I are on the same page. What I'm saying is, with the people and their ability to glom onto these conspiracy theories, that's why. Because one thing, especially when you want a narrative to be true, when you so want something to be true, you are not actually looking. You have to be really careful. You have to be self-reflective, because you're not actually looking for facts or evidence. You're looking for things that are going to uphold what you already want to be true, and then you will ignore those things instead of going into it with the goal of, okay, what really happened here. So they're saying that because I want to break down, because this chick is upset in this chat.
Don't get upset, girl.
She is upset in this chat, and I just want to dispel some shit. I'm not going to change her mind, but I want to dispel some of these rumors for anybody that may believe some of the stuff that she's saying. The girl, when she first got there, was the first and only time that she lied about glass. When they called her on it, she copped to it. She couldn't cop to it until she came out of surgery. When she came out of surgery, the police, her first interview with police, not the doctors, not the ER techs, her first interview with police, according to their records, she told them that she was shot. She told them that Tory shot her, but that information was withheld from the public because they were investigating, but it came out in trial. It came out in the pre-trial, the December before, that she told them upon their first meeting that he shot her, but they withheld that from the public because they were investigating. So she never lied once to the police. She never lied once to anybody else. She told the truth to the people that needed to hear the truth, and she didn't say anything to the public. And she came out to say things to the public after Tory and his team started putting out their narrative. So now we can clean that off. She never said that she didn't. Okay, so they're saying, well, Sean King said that he saw her beating Kelsey, and that's probably what it was. And he was just going to, Sean Kelly, and he was probably just shooting off a warning shot. What Sean Kelly actually said was, he kept saying the little one, the big one, this, that, and the other. Now
he did. I was there.
Exactly. So if you take what everybody said, Sean Kelly, Meg, Kelsey, if you take what all three of those people said, it is clear what happened. Because this man said, I saw a flash that was closest to the girl from the inside of the car. And then and they asked, did you see a gun in her? No, I never saw a gun in her hand. All I saw was flashes closest to her. But I did see him come out waving something that looked like a gun. And I saw flashes in her direction. And he was cursing. He had
an object in his hand.
Thank you.
All over the place.
And going all over towards the person, a torrent of obscenities. Now let's use our critical thinking skills here, people, class. Okay. Let's use our critical thinking skills here. If she said, now where was Megan shot? Outside the car, walking away, right? Right?
Yeah.
So if he says that he saw a flash inside the car closest to the girl, right? And then he emerged from the car shooting at Megan, or shooting at the person, and the girl fell, is what he said. The person fell, right? How was Megan fighting Kelsey. How could Megan have the gun? There was not one, and then there's proven to not be, there was no gunpowder, nor shots, or anything on the inside of the car, no bullets, no nothing on the inside of the car. Nothing was hit, no blast, no nothing. So everyone knows that every shot from that car was from that gun happened outside that car. The person that was shot outside the car. She could not be both inside the car fighting Kelsey and fighting over a gun, and also outside the car being shot. So again, this man that has been saying the little one, the big one, the this, the other. It came out Tory was, I think, 5'3". Didn't they say Tory was 5'3"?
You sure he a little guy?
Yeah, I think Kelsey was right at 5 foot or whatever, right?
She's short as well.
Meg is right at 6 foot. I think she's between
Meg
5'10".
was taller than all of them.
Yeah, she's 5'10". She's 5'10" or 6 feet. I can't remember, but she's between that. She's between that height, right? Now he says he saw two women fighting. Now let's go back to what Kelsey said. Kelsey says that when he first shot her, she ran over to Meg. She's scared to death because he was walking towards her with the gun. She thought he was going to do something else to her. She said, "Oh my gosh, I need to do." Then he hit her something there. They stopped fighting because she jumped in front of her thinking he was going to hurt her. Then she said, "I got to do something to distract him." So she took off running. She jumped in the car. She jerked the car out of gear. She said she wasn't trying to go anywhere. She was just trying to distract him to get him away from her, which worked. Because he came around, got about a hair, drug her out the car, started beating her again. So remember, this man said they were fighting over here, they were fighting over there. According to Kelsey, he was fighting her over here and he was whooping her over there. And he drug her out the car by her hair, remember? And then at one point where he says, and it looks like they were all fighting together and it was just such screams, okay? Remember, Kelsey said, dude, the driver had to basically drag and beat Tory off her because he was choking her. He was pulling her hair out. He had kicked her, all of that stuff. So he ended up picking her up, grabbing her and basically wrestling her away from him. At which time all three of them, according to Kelsey, walked over to where Megan was. Now, Megan had just been shot in both of her feet, right? She is rolling around, writhing in pain with shots in both of her feet. This man says he saw somebody screaming and kicking and they thought they were going to put her in the river. I do not in any way think.
It was like a little water area, a little stream,
Right. And so we're gonna kick her and they were gonna throw her in that water, right?
Yeah.
I do not believe in any way that Tory, Kelsey, nor the driver was about to drop her in. What that man saw was a woman writhing in pain, screaming, hollering, and kicking because she just got shot in these same feet that she is kicking. And these people, I think they were actually coming over to see about her because remember, Meg testified that Tory, I'm sorry, are you okay? I'm sorry, please don't. She's screaming at this time. That's what that man saw. Because again, he saw figures. He saw all three of them over her, talking to her, asking her if she's okay or whatever. And then that's all that happened. No, he wasn't. I don't think he was going to drop her in a river. But yes, he did see some fighting. But according to Kelsey, he whooped her in two different spots, and the man had to drag. So that's what he saw. That's the fighting that he saw.
Kelsey got on that stand and said
she ain't know nothing. She didn't even know who. She didn't even know who paid for her lawyer.
I don't know.
Who paid for your attorney? I don't know. I don't know. Can I ask my thing was, can I ask my lawyer? Can I ask my lawyer? I don't know who paid. I don't know who paid for my attorney.
This lady off the stand. I can't take no more.
and then you hear her on the tape, and she's. Let me check my notes. Give me a second because I want to make sure I'm telling this correctly. Hold on 1 second. I want to make sure that I have this part right. Can I consult my notes? Can I talk to my lawyer? I'm going to go out. I'm going to go to the bathroom. And they're asking her, do you need something to drink? Y'all need something to drink? You okay? You need to take a break? But she was under some pressure. Okay. But
Tory,
my point, yeah.
I hope Tory is listening to this. He was listening to the whole trial, child.
Exactly. So my point is,
he just thought he was just smiling and cocky at that point.
Thank you. And they were like, oh, well, she was in this seat, she was in that seat. No, the police said from day one, from those transcripts from that pretrial hearing in December of the year before, they said that when they pulled them over, that Megan was in the passenger seat, back passenger side. Kelsey was in the back driver's side. The driver was driving, and Tory was in the front. When they opened the door, they found an olive-colored gun with it cocked back. Everything still hot to the touch at his feet. At his feet. At his feet.
I
okay.
forgot about her already. That's bad. I forgot you was talking to the lady in the chat when you said they was talking about Tory.
Yeah.
Okay, I got you.
Yeah. At his feet. Okay. So not that this gun was not in a Louis bag like y'all lied to and told that was in Meg's bag. No, the gun was hot to the touch at Tory's feet.
That it was.
Okay.
You know what? We just need this security guard to come to the front. We need him to approach the bench.
But guess what? He did. Megan Kuniff talked to Mandisian, and I guess Mandisian was mad and upset that day.
I was there when he came. I was there in the hallway.
So when he said that the Megan Kuniff put out a tweet, and she put it in an article, that he told her that security guard was prepared to testify if he got on the stand, that he was prepared to testify that he nor Kelsey shot Meg.
Okay, well, if that's the case,
thank you.
Wait. So if that's the case, then Magdesian should have been kicking and screaming to make sure. You know what I'm saying? Like if it was that favorable, he should have.
No. Not Tory nor Kelsey. That the security guard himself.
Well,
nor
we
Kelsey.
Know he didn't have nothing.
Well, that's what I'm saying.
They did do GSR on his hand.
Right.
No GSR. So
and that's what I'm saying.
Nothing. He got let go immediately. Wasn't no
exactly
GSR on Kelsey's hand.
Exactly, and he was prepared to say
Meg on the back seat with her with the leg
exactly.
Her, so it wouldn't be a shocker that she has some type of GSR
because you could see the blood all over her from Meg, all over her legs and all over her from when Meg had bled all over her. But yeah, Megan Kuniff, because when I was like, no, he didn't say that. He must have been mad and thought he was talking out in the air.
Let me tell you what happened. So apparently everybody was asking about this bodyguard. Nobody knew if he was going to show up or not or whatnot. So they had already closed. Instead of them waiting, I think I would have tried to do some type of warrant for his. Well, he had a warrant for his arrest. So I would have tried to wait and seeing if he was going to show up, if he was going to be beneficial. Now, if he wasn't beneficial, then it wasn't waiting. So that's why I thought he wouldn't be beneficial. So they had already done closing arguments, and they're retiring. I remember I was supposed to go back home, but then we had a snowstorm, so I ended up staying. So I was like, "Hey, y'all, I'm back. I'm in the hallway. I'm gonna wait with you guys, for deliberation." Because I was like, "Somebody text me when you get the verdict, because I'm out of here. I'm hitting the plane." So then when I got the text that it was delayed. So we ended up staying. So I came back to the court and I was sitting in the hallway and I was like, dang, this dude looked familiar. So we looking them up on Instagram, trying to find videos and stuff to see what the bodyguard looked like. I'm like, that's the bodyguard. So we all was like, that's the bodyguard. And he had a bodyguard with him.
I heard that.
So it was like, I'm like, dang. So then he ended up going in. Then a lawyer came up. Lawyer was with him. So then they went in. And so then we all got the word that was him. And that he came. Both bodyguard. Justin also came as well.
Sure did.
After, during while they were deliberating. And then he went before the judge. I guess they must have just dropped the bench warrant because he heard he had a warrant. That's why he came. And then he left. People took pictures of him outside and all of that. Nobody heard anything else. So all of this, maybe Magdesian did tell Megan Kuniff that
he did. So she said she sure did.
And that's what allegedly happened, and he was mad about it. So maybe that's an issue that they're gonna take up, perhaps.
Because she sure put it in there. Because I said, I know this man ain't just said this out loud, because she said, I asked him, either was he going to testify or could he tell her anything about it? And she said he told her. Almost as in
there, Andrew. Right? Ray feel like you was there.
I was, girl. I was in the trunk. But no, the reason why I'm saying, you know how I am. I read every single thing because after all of this stuff was going on back and forth, I wanted to know myself what actually happened. So if there was court documents that were available, I read them, and I read her medical report. I read all of that, and that first hearing from December was a doozy because all of those people came in. That's why when people were all up, I knew the December before that Sean Kelly was saying that they were going to put her in the river. That's why they didn't want to call him. It was testified to. They asked Detective Stogner this on the stand during the December hearing. All of that came out. That's why I was surprised. Everybody was surprised that he said it. He had said that this had come out a year before. So I knew that he was going to say that, and I knew that that's why they didn't call. They knew that what he was saying was truthful, but they also knew that he was confused.
Let's back up, Andrea. So what was Megan Cuniff talked to Magdesian,
Mm-hmm.
and Magdesian said that the bodyguard was going to
was prepared to say that the bodyguard himself did not shoot her, and that Kelsey did not shoot her.
Okay, so why would Magdesian tell Cuniff that? Because that doesn't.
That's why I said, I was like, was he mad or something? Because
I'm so confused.
it was in a tweet. It was in a tweet. Because I have to look back and see if I can find it. She didn't delete any. She didn't delete any in her tweets. It was back during, but it was as they were coming out, and she was asking him, either they were coming out or was lunch or something. But she did a tweet on it, and she included it in an article. But nobody picked up on it, and nobody said anything about it. It was kind of like a little buzz when she said it on Twitter that day. Mm-hmm. But after that, it was nothing to it because he didn't testify or whatever, and everybody just kind of threw it up to he wasn't going to be helpful.
Yeah, I figured he wasn't going to be helpful if he didn't kick and scream about him, because there was a warrant for his arrest. Because honestly, in a motion for a new trial, when they did that motion for a new trial, I would have included that if he was going to say that it wasn't him or that Kelsey did it. I would have included that and said that, hey, I wanted the judge to reopen proofs, and he didn't because they were already deliberating, because he should have asked the judge to reopen proof if it was something that was beneficial to him, and they didn't do that. And that might have been something that would have perked the ear of the Court of Appeal. So I would presume that because that didn't happen,
it wasn't going to be beneficial. And so, because I was laughing, I was like, see, even this dude here wasn't going to tell him. But then, even after that, they were talking about the phone calls or whatever. Nobody really, why are you calling I'm sorry for sleeping with two friends. You weren't drunk at the time you slept with them. So what was you talking about being drunk? What did being drunk have to, I was just too drunk at the time. What did being drunk have to do with sleeping with two friends? If that's what you were calling about, you were talking about you were too drunk that night.
Well, it's kind of crazy because we heard a lot of testimony about his alcoholism. And in one breath, they were saying it was just so like he's to a point where you black out and you don't remember, I guess. But then he was a functioning alcoholic.
Which one is it?
Go through like day by day. They can drive a car. They can do all of that stuff because they wake up in the morning sipping. So it was like everything they were doing at that sentencing hearing was kind of talking out both sides of their neck.
I think it was, if this doesn't work, I'm gonna throw this up. I'm gonna throw this on the wall. If that doesn't work, I'm gonna see if this slides down the wall. But my other thing was, okay, for Kelsey, people are like, oh, you just have to understand that was her friend. Yes, she was being a friend when I don't think either one of these women gave a care about this man. I don't think that their argument was even about this man. I think Kelsey was, y'all bear with me, because I'm not trashing her too bad. I think she was needy, right? I think that, you remember, like I said, Meg, when she got to the hospital, first they were evaluating her, then she went to surgery, then she went to recovery. She's under drugs, she sleep. So for probably more than 24 hours, Meg probably wasn't able to talk to anybody, especially her, right? Remember, within the 24 hours, she started getting antsy, getting paranoid, thinking that she didn't want her around, and she didn't want this, and she didn't want that. Plus, remember, Tory is calling her. He in her ear, see, she cutting you off. See, she cutting you off. You see what I'm saying? But when actuality, the girl is unconscious.
I do think it was interesting how Meg did not, according to the testimony, she ain't want to be bothered with Kelsey at all.
You know why?
That shoot, like Kelsey
People have to
literally was
remember.
trying to check on her. Kelsey made it seem like she was trying to see,
Mm-mm.
like she flew Kelsey. According to Kelsey, now this is what she was clear on, even though she was clear
Mm-hmm.
on everything. She said Meg moved her from Texas to come down there and be her personal assistant.
Mm-hmm.
She gave up and sublet her apartment and everything to somebody else.
Yep.
She had no place to go. And she said after that shooting, like basically Meg and her team was like, we about to take you to a hotel. We'll pay for that for a couple of days, but you got to head back. You got to check.
And,
She don't
but,
want to. Like they wanted her. I don't
and
know
that
if
wasn't
that was part of the PR situation. I don't know what it was, but it was just real weird. And they have not been friends ever since. And then of course they had the diss tracks on. She did the whole diss track on her. And
so here's the whole truth. Meg actually paid for that girl's rent for a year. And she flew her.
Yeah, she said that.
Yeah,
that
she flew her. She flew her back. But here's the thing: what people don't remember, the reason, because they remember Meg is asleep at this time, right? Whatever she recovering. Tory is talking to her on the phone. Remember, Tory called her and wanted to meet her. It was like the next day or whatever. Wanted to meet her about this money. What people don't remember is another friend was there, another one of their mutual friends. It was like a group of 3 or 4 of them. Another one was there with her when Tory did the call, and she was listening to the whole thing. And she started talking about she was contemplating taking the money, right? And she left and she went to meet him and all this kind of stuff. That friend, this is why Meg did the cutting. That friend told Meg about all of it. That she had went and met Tory, that he was talking about the $1 million, that she was actually considering taking it. That's when Meg said, "Oh, wait a minute."
Okay, that makes sense. Sense.
But because I said people didn't want to look at none of that. It was actually recently, the tweets, apparently it was an online war at the time, within months of all this happening. That friend came out and she said all of this all over social media because she was mad because, again, the smear campaign was going on, right? Meg did this and Meg that, Meg this and Meg that. But turns out this girl was sitting there and Kelsey had played her some voicemails of previous of him talking about, but the lawyer said, and how supposedly Sean Holly said, I had to invest in your business. Well, this girl heard the voicemails and she was there listening, and Tory didn't know. And then she told Meg, hey, but this girl, Kelsey, if she just would have waited, in my opinion, she felt like, I'm calling her, I'm trying to check up on her, I'm going to the hospital and she won't see me, they won't let me in. The girl is in surgery. The girl is in recovery. She don't know you trying to check up on her at all. You know what I'm saying? Let her wake up.
Hold on a second, Andrew. That's what I was gonna say. Be woke. She got to be towards the beginning of the because she making these comments. Like she talking about Tasha K.
Yeah,
so we talked about Tasha K in an hour, but I get it. I'm gonna have to change my thumbnail because we talked about everything.
Yeah, but you know what I'm saying. So the girl. If you remember when she was all upset. I tried to go up there. I tried to see her. They wouldn't let me see it. Meg wouldn't answer her phone. She wouldn't text me back. Meg was, and now we know Meg was in surgery and she was knocked out in recovery. Then by the time, because it was within 24 hours when she started entertaining Tory, I think that she thought that she was supposed to be left out. I think she thought because Meg did not suggest for her to go back to Houston. Go back and read everything. She reached out to them and said, well, I'm going to need to go back home or whatever. She got mad because I said, this girl must be crazy. She got mad because they got the ticket too quick. Said that they must really want me gone.
Yeah, she did say that.
She got mad. She asked them for a ticket. She said that she wanted to go home. They made it happen, and she got mad and said they got the ticket too quick. Again, what do you want? You just said this is what you want. You said you want to go back home because you didn't feel safe or whatever. They made arrangements to get you back home and said they would get all of your stuff back home. And then Meg paid for your rent for a year. They told you, sit still. We're gonna have to, lay low for a little while, and we're gonna have to reboot everything within so many months or whatever. It may take up to a year. We need to find out. We haven't heard anything. Again, she's still laid out. So this is the people telling her. She's still, we don't know about physical therapy. We don't know how long it's going to take. We don't know about all the damage. They telling this girl that. She is saying that they telling her that. but I think she's weak because she wasn't in the know at the time. She wasn't there. She wasn't hearing everything. And then she got Tory in her ear. And so she's believing all of this crap, that they're saying. And so she started getting paranoid.
Mm-hmm.
I think she started getting paranoid, and she did this to herself. All she had to do was lay low, like they said, fly back there. They had paid your bills. They had given you, they paid your rent for a year. All you had to do was lay low. You had nothing else to do.
All right, then. So,
I'm
Tory,
gone.
you get all of this, Tory? You get
I'm
all
sorry.
this? Andrew done broke it down from the beginning to the end. Thank you, as always, for coming up and for your commentary, Andrew. Hey,
Child. Hey, girl. Hey. I put a note in there for you. You can be, I'll be a mod for you, girl.
That's what you came up here for.
No. I came up here to laugh at Bishop Limore and his lawsuit trying to get money put on his books because he know he going down. Tasha K gonna win this one because everything that was in everything that what you read, it was true. It was true about him. She didn't say nothing no different about him that was not in the depositions.
Yeah, that lawsuit.
Am I right?
But that lawsuit, I think she did quote what was in that complaint from Gloria God. It was a very interesting complaint. I never went over it because honestly, I didn't understand it. It was just all.
That's probably why he got mad, because he had Gloria God over there if she did.
Yeah, somehow I guess she got it from the complaint. That's what they attached, was the judicial record. So I mean, that's something that you can commentate on. That's what we commentate over here. All right, LJ007, thank you so much. And hopefully I'll be on tomorrow. So thank you for joining us, though. Have a good night.
But you know it. But I think he's just so all on the internet claiming, oh, this is my homeboy. We tell him we go back with all of, since they doing that hip hop 50 thing. Mm-hmm. And I be seeing him on there and I'm like, when is you going to jail? I'm sick of looking at them greasy lips and them fake suits that you go get down in Korea town. But I think Tasha may win this one.
Okay.
That's my opinion.
Well, you're gonna be our last commentation because it's 12:30 over here. Your girl over here about to doze up. I love y'all, but
11:30 here and I was about to fall asleep. I know, right?
Thanks for coming up. Y'all, make sure you guys hit that Cash App, hit the like button, subscribe if you haven't done so already. Thank you so much for the super chat. Hit that membership. I'm gonna be dropping some in the membership tomorrow because we got something going on this week that you guys might be interested in attending. That'll be online. But thank you guys for rocking with me for these 2.5 hours. I appreciate it. I hope you guys enjoyed yourself. Make sure you guys hit that like button on your way out. Jeff, shut up. Right, Andrew was like, was you next to me in the courtroom? Because she remembered all that stuff. I be trying to put Tory behind me. I ain't even gonna lie. I'm so over Tory right now. So, but anyway, you guys know we're gonna end with my little bop, and I'm gonna holler at you guys. Make sure you guys have a good night. Again, go ahead and hit that like button if you haven't done so already on the way out. Talk to you guys tomorrow.
Yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of conflict or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes? Tired of all these blogs running lies because they agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
One last thing, Thais, if you want to go on over there to your channel, we can keep the fire burning over there. But your girl is out of here. I gotta go. I am so tired. Love you guys, though.